and have some type of agreement. It could be a one-page agreement, could be 20 pages, doesn't matter. Having those agreements in writing is my recommendation in this case. And of course, I've mentioned this before, and it is important to have any type of agreement that you have reviewed by counsel. And that's another mistake we'll talk about later. But and it's important that you have your attorney and your future partner has his or her own attorney. And I'll tell you why, because the interest might be different. And this week I'm reviewing a partnership agreement for a client, and the other partner has his own attorney. My client has me as an attorney, and we're going through changes. The goal is the same for both parties. The goal is to have an agreement that they can both live with. However, the interests are different. So it is difficult to have one attorney do the agreement for both parties unless the parties agree that it's simply more an administrative function, that they have agreed to those terms, and the attorney is going to put those whatever they have agreed upon into the document. That is fine. If both parties agree to that, listen, we agree to those terms, we're not going to change anything. We don't need your advice, simply I need you to put it in a format that it can be understood. That's fine. You can do that, but the attorney will discuss that with both of you. So there are exceptions to every rule, but usually it's good to have each partner to have their own counsel. If you're negotiating terms within the agreement. Mistake number 2 is not defining roles and responsibilities. And in this one, it is very common when you have an operating agreement that is downloaded from the web, or you create something through AI. The roles and responsibilities to the partners is not going to be there. They're not going to be there simply because the form does not know what you're going to agree to, and AI will not know that. Okay,